Good afternoon, everyone. My name is Kate Shank, and I'm the Deputy Director and Chief of Staff at Legal Aid Chicago. Welcome to our fourth and final session of our series, Legal Aid Matters. Today's session is titled, The Right Time for Right to Counsel. This presentation will outline Legal Aid Chicago's Right to Counsel pilot program, which we do in partnership with the Law Center for Better Housing and CARPLS. Before we get started, a couple of administrative details. First, please sign in with the link found in the chat to obtain CLE credit and to give a course evaluation. We value your feedback. Second, if you have any questions or comments during the presentation, please use the Q&A function at the bottom of your screen. We'll address as many questions as time permits directly following the session. Third, we will be recording the session so that we can make it available to those unable to attend. The recordings for this session and our previous sessions will be made available at the end of the series, which ends today. And a copy of the PowerPoint will be emailed after the presentation. So what I'd like to do now is to turn it over to our panelists to get us started. Welcome.
Good afternoon. I'm Dennericka Brooks. I am the Director of the Housing Practice Group here at Legal Aid Chicago, and I am going to ask my colleagues to join as well and introduce themselves, I should say.
I'm Pat Wrona. I'm the Legal Director at CARPLS Legal Aid, and we are proud partners of the Right to Counsel with the Law Center and Legal Aid Chicago. So happy to be with you all today.
And I'm Michelle Gilbert. I'm the Legal and Policy Director at the Law Center for Better Housing. And sometimes I forget to say Law Center because we changed our name just a couple of months ago. So you might be familiar with us as the Lawyers Committee for Better Housing. Same acronym, same great legal services.
All right, so why are we here today? Let's talk about right to counsel. Why should we care about right to counsel and right to counsel in eviction cases? First, let's specify that the right to counsel that we are talking about is in eviction cases. There are other jurisdictions that have expanded that to other areas of the law, but for today, we're talking about those cases that involve evictions. And we're talking about evictions, and we care about evictions because of the housing displacement and the displacement of families. It is devastating to have to move or to be evicted for a lot of reasons. It's disruptive to individuals, it's disruptive to their families, and it's disruptive to the community. And so we want to think about that in a lot of different ways. When we're talking about that disruption and the destabilization, we're talking about school disruption, a loss of learning opportunity, a loss of educational attainment. We're talking about adverse health outcomes, diminished mental health capacity, increased depression and anxiety. We're talking about financial instability, the loss of hours of employment that comes from having to shuffle from one place to another, the loss of employment opportunities altogether because of traveling disruption, and then also short-term and long-term housing instability, difficulty finding immediate housing in the short term, but also in the long term as a result of filings and eviction records. And when we talk about that disruption, we talk about, or we should also consider the racial justice impact of evictions and that they have on individuals and families. Studies have shown us that Black women are disproportionately impacted by eviction. In fact, they are 2 times as likely as white women to be faced with eviction or have an eviction filed against them. Studies have corroborated this and found this, and we're learning the importance of data that really does corroborate the work that we do, what we see. So pre-COVID-19, as tenants advocates, as housing advocates, if you went into any of the eviction courtrooms in Cook County, you could see the benches lined with Black women. And most often those women were women with children. Now there's actually data to support that. There have been research that has been done. There have been studies that have been done. Matthew Desmond, an author and a researcher, has actually put out a study which also shows that women with children are more likely to face eviction. And of the children that are impacted by eviction, 15% of children will be impacted or experience eviction by the time they reach age 15. 15 years old, and 15% of children will have faced an eviction. Of that, if we actually get back into the demographics pre-COVID-19, 20% of those children will be Black children, 17% Latinx children, and 11% white children. So again, just another way that we have data to show that Blacks and Latinx families are disproportionately impacted by eviction. And that came from a 2018 study. But we should also look at it after and during COVID, the impact of COVID-19. It will also have an adverse impact on Black women and women specifically. There have been long-term and long-standing adverse impact on women. The World Bank actually released a report just last year to talk about what the world has seen and what researchers and analysts believe will be long-term effects of COVID-19 on women. Women were disproportionately affected by the pandemic. When the stay-at-home orders took place and schools shut down, depending on where you lived and how long that lasted, it really was women that bore the brunt of a lot of the impact of that. Women had loss of income, loss of employment opportunities, in part because they had to stay at home with their children who could not go to school, or who had inflexible or schedules that were too flexible because of COVID outbreaks. When the school shut down because of a COVID outbreak or because of remote learning or hybrid learning, women were disproportionately the people that had to stay at home and take care of those children. So with that being said, we anticipate that there will be lingering effects of COVID-19 pandemic in childcare in hybrid environments, as people that work in the workplace have to be more flexible about what their work looks like and those work hours look like. That being said, let's talk about what the right to counsel has looked like and what it looks like now in 2023. So prior to COVID-19, there were 5 cities that had established right to counsel programs, or that established a guaranteed right to counsel program. Started in 2017 with New York, expanded in San Francisco, Newark, Cleveland, and Philadelphia. This all happened prior to COVID-19. But since the pandemic in 2022, there's been an expansion of right to counsel projects across the country. And as you can look here, from the north to the south, to the east, to the west, really those right to counsel programs have really blossomed. And that has been in part due to what we all believe will be the tsunami of evictions that we were all anticipating, because people could not work. There was a loss of income. People couldn't pay their rent or pay their bills. And so there was a movement to actually get more resources available for tenants that would likely face eviction because of their inability to pay rent, lease violations from being doubly housed or having multiple families in one place as families combined, and a lot of other issues that were the result of stay-at-home orders and people being in place. So you can see here just the proliferation of right to counsel programs across the country in different cities and municipalities. And aside from cities, there have been 3 states that have enacted right to counsel programs. In 2021, Washington State, Maryland, as well as Connecticut established right to counsel programs in their various jurisdictions. Now, right to counsel really does vary depending on where you live. There are some municipalities that have a right to counsel for all, as you can see here: San Francisco, Boulder, Baltimore, Minneapolis, Kansas City, and New Orleans. And then there are other categorical right to counsel programs where your right to counsel may be based on eligibility factors like the federal poverty level, whether or not you have a child in the household or the age of that child. And so right to counsel programs really do vary by municipality and city. I will say that in addition to that, there are pilot programs that also started. Santa Monica has a pilot program, Rochester, Milwaukee last year, and then Chicago last year were just among the places that also have what are defined as pilot programs. So right now, there are 3 states, 15 cities that have legislatively adopted right to counsel programs. And then within the other municipalities that have not legislatively adopted right to counsel programs, and even those that have, lots of these municipalities have used federal dollars and CARES Act money as a way to actually fund these programs and to establish pilot programs so that we can see whether or not these programs work, how they work, and how they can be altered to get the maximum impact out of them. So why are we talking about this? Why is it important? Well, it's also important because the programs that have been established for a period of time now have established that the cost of the right to counsel, it varies from city to city. It's largely depending on the size of the city and the scope of the programs. What have they set out to do? What are the deliverables? How do you analyze those deliverables? And one of the ways that those deliverables have been analyzed is through Stout, Reeses, and Ross. They are a financial advisory firm that have produced several reports across the country demonstrating just how these laws are cost effective for cities to provide large financial returns to cities. And the reason that's important is because when families are disrupted, when they are destabilized, they lean on other structures within the cities. They lean on hospitals and emergency rooms as a place to actually stay. They lean on homeless shelters, social service providers, and other social service safety nets to really get them by until they can actually establish rights or establish housing stability. So through Stout and through some of the work that they've done in these programs, we know that in New York City, Stout estimated an annual investment of $199 million by the city, but that would avoid annual costs of those social safety nets of $320 million. So the return on investment was $1.60 per dollar spent on right to counsel. In Philadelphia, the return on investment is $12.91 for every dollar invested in right to counsel. And in Los Angeles, the return of investment is $3.48 for every dollar. And I'm proud to say that Stout is also working with us here in Chicago on evaluating our programs by providing independent evaluations on what is being done and what we are aiming to accomplish. Additionally, we know that right to counsel is important and can be important because some of the things that I stressed earlier. If you have an eviction on your record, and I'm not just talking about those folks that actually are evicted from their homes for lease terminations for non-payment of rent, but just the mere filing of an eviction on your record, it leads to a cycle of instability, housing instability, economic instability, where you have job loss, decreased housing choice because that eviction filing serves as a stigma or a red flag in a way where landlords don't look at the underlying basis for the eviction filing. They just look to an eviction being filed and somehow think that the tenant must have done something wrong if an eviction was filed against them. And that's just not the case. Sometimes there's an eviction filed because the landlord has sold the property, or the tenant has stayed after the lease expired, or some other reason that has nothing to do with fault. And even if there were fault, life happens. We saw it in COVID. Life happens, and many people are 1 paycheck, 2 paycheck away from being unstably housed or unable to pay rent. And the COVID-19 pandemic really laid bare that across the board, people are struggling to survive and barely making it. But also, eviction filings can lead to child education disruption because children can't concentrate on school if they don't know where they're sleeping or where they're supposed to go after school or getting back and forth to school and truancy. And that leads to community destabilization, desperation for those folks that are just trying to make it, and which can also lead to increase in crime. And there's just this cycle. But with right to counsel programs and housing stability, if you don't have an eviction on your record and you're able to avoid eviction, you can stabilize your credit. You can maintain your employment because you don't have to worry about going back to forth to court or missing or long commutes. That leads to housing mobility, having actual housing opportunity to apply for homes in different areas, increased educational stability, community stabilization because families and individuals are stabilized. That leads to decrease in crime, and community investment because those numbers then go down. So all of these things have been attributed to the benefits of having right to counsel programs.
So I'm going to talk a little bit about why counsel, why we think that having an attorney is a solution. The number of different things that the court can do or that the county could do, why right to counsel as an eviction prevention strategy. The first thing that we do as counsel on cases is provide information to tenants. Very often it's the tenant, it's their first time in court. If you go to court often, like Dennericka and I and our staff attorneys do, it just seems like, old home. But if you never go to court, it's pretty scary. As you know, also, lawyers love to kind of change a word and we use it in a certain way. If you have any familiarity with this, we talk about the judge will stay an eviction order. And then people think, well, stay, because what does stay mean to a non-lawyer? It means that they get to stay. So it's a very confusing place for people who don't go there routinely. And so that's the first step in what we do. The calming down, saying, okay, we can help you with this. We do this all the time. So and this is the essence of the early resolution program that all of our programs, plus some additional providers, are working on, that we counsel the clients. Well, as you know, an attorney doesn't have a vote in what happens. Our goal is to try to help that tenant achieve their goals, but helping them figure out what their goals are, the different possibilities. When I'm sitting with the client and mapping this out, it really looks like a tree. You could do this, or you could do this, or if you do this, this would be the effect of that. So just that having someone to be able to explain that, and then to attempt to negotiate. So that's the work that we do in the early resolution program. But we're not able to resolve all of the cases through the early resolution program. And I will say, I think that we, LCBH and Legal Aid Chicago, are especially effective in ERP because they know that the other side knows that we will keep cases. But so it is not just a matter of our opinion. I mean, obviously we think, oh, well, lawyers, of course, having a lawyer is helpful. We actually have research that indicates that having a lawyer is helpful. Of course, as you know, as we've talked about already, that very few tenants have attorneys when they get to eviction court. But we know from an evaluation of a decade's worth of eviction records that having an attorney makes a difference. A tenant is less likely to have an eviction order, and having a legal aid attorney especially decreases the likelihood that there'll be an eviction order entered. I include this little snip of a slide for two other reasons too. Again, there are different ways to persuade people. Some might be persuaded by hearing a great story. which, we lawyers love to tell stories about our cases anyway. Some people are more persuaded, they want the data. They're not persuaded by one story, they really want to know the outcome. And so LCBH collected this eviction data. And if you haven't looked at it, I would encourage you to do so. It's really interesting, and I can brag all I want and not seem immodest because I did not work on it. But you'll notice the date here, May 2019. I don't think we would be where we are right now if it hadn't been for the pandemic, but don't anyone think that this is something that our three organizations started working on only because of the pandemic. I mean, we were involved in trying to bring Right to Counsel to Chicago before the pandemic, and we will continue to advocate that it should be part of our permanent law once we are over this period. So next slide. Again, why in particular having an attorney as an eviction prevention strategy, or why is it that those legal aid attorneys make such a difference in the outcome in eviction court? Eviction court is, like any court, an adversarial process. It works when both sides have an attorney. It is not the role of a judge or a courtroom clerk to answer questions or explain the law to the people who come in unrepresented. It's just easier to talk with someone who is speaking the same language that you do. And I don't mean this in any way negative to judges. I think that, if a landlord is unrepresented, a judge might turn to look to me to explain what the history of the case is or something. They are in eviction court, they are doing a lot of cases, and having the person there who can explain it in the language that they use makes it more likely that they will be able to hear. Again, for tenants specifically, they don't know the language, they haven't been to eviction court, they don't know about the notices, the kind of cases where we are prevailing in Right to Counsel. We are filing motions about improper notices, and those procedural defenses are all really important, and that is what we are training our staff attorneys to do. Not something a tenant is not going to just, pull out the landlord-tenant ordinance on their own. And then finally, there are a lot of judges who actually support Right to Counsel because they know then that they're entering a truly agreed order that has been explained to by a tenant, or to a tenant, sorry. So I get to share the CLE code here, as you can see, CH, you know what? Is this CHI 234, or I bet it's CH 1234. I'm gonna have someone from
CHI 234.
Okay, thank you, Dennericka. I realized that I'd seen it before, but I had not actually said it out loud. So I'm gonna hand it over to Pat now, and then I'm gonna come back a little bit and talk more about the actual Right to Counsel pilot project.
Michelle. Well, now that we have the very important matter of the CLE code out of the way, I want to talk about some other things that we found that really have mattered to the design and the language around this project that is such an important thing that we're working on. And we did find that language matters. We talk about right to counsel, but really there isn't yet a right to counsel, not in Chicago, because at this point we're working on a pilot that should establish that there really should be a right to counsel in eviction. So at this point, tenants are not able to sort of demand an attorney in their proceeding. That doesn't exist yet. And, to be very honest, the pilot here is going to help a relatively smaller number of tenants versus how many evictions are filed every year in Cook County. So we have really found that that language, right to counsel, is a bit of a misnomer at this point in time. Because right now it's aspirational. This is all part of a very exciting movement, as we've heard from Michelle and Dennericka. Many cities, municipalities, localities are trying to bring this right to counsel in eviction cases, which is, those of us who work in legal aid, there's so many civil matters that it would benefit by a right to counsel. But housing is the place to begin because it is so important to the human person and human dignity to be housed. So all these programs are trying to find attorneys really for more extended representation, more direct representation, and kind of another language that we kind of put around this program. So not just advice or just settlement, because while those things are very important, not every case is resolved by advice or settlement. Has a settlement possibility. And some cases do actually have to go through to trial. And for the landlord bar to know that there are lawyers standing ready to do that important last step is very important. So right now in Chicago, there isn't this right to an attorney in eviction, but so many people are working toward that in legal aid, the housing advocate, social service, and very important, the courts and government to move us in that direction. So we also use direct representation project as a word to describe this. While I think it's important to say right to counsel, because that's where we want to go, and let's use that language to move us in that direction. When it comes to managing client expectations, direct representation project tends to help a little bit, so people understand that this is somewhat limited. So how do clients begin to have this journey that may end up in a right to counsel representation? And we have found that getting the word out through all the possible channels is the way to go. And my organization, CARPLS, has had the honor to run really kind of the technology that allows people access to the beginnings of these programs, which may lead to right to counsel. And that all really began with Cook County Legal Aid for Housing and Debt, thanks to the Cook County, being part of this program and the Chicago Bar Foundation. We were able to establish, first of all, a website, and that's cookcountylegalaid.org, which is where people, where they find all the information now on the internet, can go and find out how to really begin this process. So in addition to people finding us about this program on the web, every eviction summons on the back of it says, do you need legal help? And the prominent phone number on there includes the 855 phone number for Cook County Legal Aid for Housing and Debt hotline, which is run by CARPLS. So CARPLS attorneys are answering that hotline. And so that is really a way to provide people with like an immediate, they get a summons from the sheriff. Oh my goodness, I'm being evicted. I need help. And so immediately they turn it over, they see this phone number, and they can connect with an attorney to begin that very important consultation, that early advice that we were just talking about. So we can begin by answering questions about the process, about the timeline, about how this is going to work, how they are not alone. This is probably not going to be as bad as they think because there's a lot of help available. So to really start helping them make those good early decisions, one of the biggest problems with eviction is people ignore it. They get a summons, they think, I can't go to court. I know I haven't paid my rent. I'm too scared. And we are there to tell them, no, you want to participate in this process because due to the early resolution program, which is the in-court part of this, and the ability to start to connect to getting rental assistance, this may turn out much better than you think. So we are there to provide that information very early on through the CCLAD hotline. We really found that the partnership with the court was very important. Cook County actually revised a lot of the procedural rules around eviction through a general order that really made a huge difference. And just a couple of the items that I wanted to highlight were eviction cases used to be a huge docket, like a huge paddle call of 1,000 cases every day of people being evicted. And what the general order was able to do was to put that into something much more manageable, like hourly batches, so there weren't such wait times, and they were able to manage then the flow of the referrals into the early resolution program to be able to talk to a lawyer actually as part of court, which CARPLS, as well as lawyers, the Law Center and Legal Aid Chicago, as well as several other legal aid programs, are all in Zoom court for these eviction matters. To that point, everything was always in person, and now all of these eviction cases are heard through a Zoom court setting, which is very helpful to tenants, that they don't have to come downtown to attend court and really participate in this process. Before, default judgments were very common, and on the first day, the first court date was in eviction, every day is a day for trial. So the first day, if you did not show up, that was your trial and you missed it, you got a default against you. Now, everyone gets an initial case management date, and nothing's going to happen at least 2 times. There's 2 opportunities to go to court before a default judgment could be entered. So that's extremely helpful to tenants because before, if you miss that first date, you're 5 minutes late, it's over. You got an eviction order. The judges, too, inconsistently granted continuances to tenants. You step up and say, Your Honor, could have a continuance to seek legal counsel. Some would say yes, some would say no. So now all the judges as part of this program give everyone at least 14 days to consult with the early resolution legal aid partners, and sometimes even longer than that. So that's very important. And then finally, what was happening is tenants were agreeing to orders without understanding what they had said yes to. And now every defendant, they really have a chance to review any agreed orders with a legal aid attorney before the judge enters it. So these changes were very important, and we're so grateful to the court system for seeing these issues and seeing what could be done here if we all got together on the situation. So the early resolution project is really the in-court part of all this. The hotline, exists kind of for the before part of it. So there are these sort of pre-court services. We're doing community outreach. We have the website. We have the hotline where people can get advice. They can find out about how do we go about settling this matter, resolving it without having to have a trial. We also have the availability to use the Center for Conflict Resolution to actually do mediation. So if just settlement between the parties doesn't work, we can get a third-party mediator involved. And then the very important step in eviction of connecting to rental assistance, because so many people, because of the pandemic, because of the financial situations of that, were unable to pay rent. So they have huge back rent that's due. And there are these great rental assistance programs that provide them with the money to be able to offer a settlement to their landlord. Which then brings us to the in-court part of it. So on the day of court, which is on Zoom, people are, hopefully coming to court. And with, again, the Center for Conflict Resolution, they're doing the in-court case management. So they're taking clients that are referred by the judge and then giving them to legal aid partners who are in breakout rooms. And so there's this next level of legal consultation that can happen to really start talking about what are your goals? Are you able to settle? What do you want to see happen here? Can get you going on rental assistance, and really doing that really more in-depth review, which then can lead to case resolution. So thus the early resolution part of the name. So we get a lot of situations where there can be an agreed move out. There can be a voluntary dismissal because the landlord and their lawyer has done something wrong in the case. Very popular is the pay and stay agreement, which is I'm going to get rental assistance. I'm going to pay you off all the rent that I owe. And because I've been a good tenant, other than this, you're going to let me stay. So that's very helpful all around. The landlord gets the money, the tenant gets to stay in the unit. And ultimately, these cases sometimes are a way to find good candidates for full representation, to take on the case through trial. Michelle and Dennericka and their teams saying, we are in this case till the end. And with all of that, I guess a really interesting thing about our kind of coordinating role in this project has been data. We had mention of Stout, and they are doing a lot of the data analysis here. But I think, part of the design of these programs, which I've found interesting over the years watching the different programs develop, is what is success? Success, is it legal success, winning, losing, or in this situation, is it optimizing the situation and maybe mitigating harm that might happen if there was not an attorney involved for the tenant? So I think it's interesting that generally there's not like a control group when it comes to the data. We don't want to have a program where we say you get help and you don't, because we don't want to help you because we want to see what happens to you if you don't get help. So really the interesting part about the design here is this project is open to everybody. So we are finding some really interesting data points. So far, 13,500 some eviction tenants have received these in-court early resolution referrals where they get a chance to talk to the attorney as part of Zoom court. And at this point, 22% on average have resulted in settlements. So that's like 3,000 settlements that have happened just since we started all of this. And interestingly, of the cases that don't settle, so that's about 10,000 so far, about 20% of them probably meet the basic criteria for being an RCC referral, or to possibly get longer representation. I find it super interesting that Legal Aid Chicago and the Law Center actually have a better settlement rate than the other partners in the project. And I think that that's partially because they know that the landlord bar and the landlords know that these are the two partners that are doing the extended representation through trial if necessary. So they're doing better than the rest of us at 30 to 33% settlement rate. At this point, over 618 Chicago tenants have benefited from this longer term right to counsel service so far, which I think is terrific. And we've learned a great deal from all of that. So I think my conclusion of this all is that the early intervention and early resolution really does help make the right to counsel part of this work much more manageably. These resources are limited. There is no way there is going to be a lawyer for every tenant. That's just not going to happen. So really tough choices have to be made. And so before that decision point happens, to be able to siphon off the cases that can be resolved early, that will benefit from a settlement and early resolution, leaves us with the remainder that then we can figure out, who is going to benefit the most from having an attorney for the long run. So for tenants, who aren't able to resolve their cases and those who have meritorious defenses, the right to counsel program is really where they need to be. So those are just some thoughts on sort of the design and the mechanics of how it's all works.
We began the Right to Counsel pilot project in July 2020. The three partners within the Right to Counsel pilot project are LCBH, which is the lead agency responsible for the reporting, CARPLS, and Legal Aid Chicago. Legal Aid Chicago and LCBH can keep cases that have been referred to us through the early resolution program. And we also bring in right to counsel cases through our traditional intake. We accept cases that CARPLS refers to us, and those can be cases that they handled in the early resolution program or cases that have come in through alternate means. One of my favorite cases that we've handled so far came in because the client went to CARPLS Municipal Court Advisory Desk. We began counting or keeping our own cases for this extended representation in July. And then there was some additional work on this referral process. And, referral process, that just kind of sounds like some nerdy thing that has nothing to do with benefiting tenants. But in 2019, if CARPLS got a great case that they said, oh, LCBH or Legal Aid should take this case, they would give the tenant another phone number, and they would, maybe, because we all know each other, they might send somebody an email. Or if we had a great case and we said, oh, but the other partner should take the case, again, we'd have to give them another phone number. But because of implementing this right to counsel, and also through ERP, we are able to make this referral electronically. The client doesn't need to call us. They don't need to do another intake. We get documents, we get the information that we need for the demographic reporting, and I'm just really pleased that we've been able to make that system improvement. So as we've said, we've seen 618 cases. They are spread geographically throughout the city. We're not putting them in wards or community areas, but we know from the zip codes that we have represented someone from 50 of the 60 zip codes in the city of Chicago. However, and now going back to where Dennericka started, we know that the zip codes that have had the highest number of cases are those zip codes in the south and west sides of Chicago. And because when we look at the demographics of these cases, we can see that largely we are talking with Black women with very low incomes. Most of, more than half of the clients that we have seen in Right to Counsel so far have incomes at or below 30% of the area median income. And for that reason, as attorneys, I think about Right to Counsel, about due process, right? But Right to Counsel is also a racial justice issue that we need to address eviction court because of the impact it has on the basis of race. So what are the next steps? There was legislation introduced in this spring session. The sponsor, very exciting, had heard about Right to Counsel in other places and introduced a bill. There was a good hearing in the Judiciary Committee. There was no vote in Judiciary, but this is not going to be, one of those bills that get passed really quickly. There is still effort ongoing, and the Bar Foundation, of course, is, really taking a lead in working to increase funding for representation. And we're all still trying to decide how exactly Right to Counsel should look going forward in Chicago and Illinois. And maybe that's an advantage of not being the first city to do this, that we can look at what's happening in other jurisdictions and help us decide how best to work on it. So while there was state legislation, probably more likely that we will be able to codify something on the city level. So if we look at that, next slide. We have already done a lot of the work that we need to do in Chicago and Cook County. As Pat described, we've made changes in the courts. We've also made changes in the substantive law in ordinances passed in the city and in Cook County. We have a lot of support from leaders who've been involved in creating the early resolution program and have been supportive of Right to Counsel. So as we collect data, and again, both programs are being evaluated by an independent evaluator. And as that information becomes available, we will use it to work towards enacting Right to Counsel as permanent law. And that may well be that we start in the city of Chicago or in a Cook County ordinance. I'm not gonna go into a large analysis of the last election, but we're feeling very good that Mayor-elect Johnson is well aware of the needs of tenants. He was the lead sponsor of the county's Just Housing Amendment, which addresses people who have been criminal justice involved in being able to get housing. And he was also one of the lead sponsors of the Cook County residential tenant landlord ordinance when they when that passed the county in 2021. So we know that we have someone who's aware of these issues, who's now going to be sitting in City Hall. There are a lot of things, though, that need to be addressed, as well as right to counsel, that organizing community is involved in just cause, and working on additional funding. I know that I will continue to work towards additional funding for rental assistance as well. So I'm very happy at LCBH. We're involved in the working on getting right to counsel adopted as part of substantive law. If you would be interested in participating in that, we have an email list that we're accumulating. I think I can send that out in the chat. Google form, send us your name and email, and we can provide more information. Just remember that this is legislative advocacy, or moving towards legislative advocacy. So you don't want to use your work number, your work email, if you are at an LSC funded program, but very happy to collect your home email and send you emails there. So I know that I've already seen that there's some Q&A, and I'm happy to answer questions. I mean, we're all happy to answer questions. And so I hand it over, I think, back to Kate.
Great. Thank you so much, Michelle and Dennericka and Pat. That was an incredible presentation. And just want to say on behalf of Legal Aid Chicago, we're so appreciative of the partnership with LCBH and CARPLS in this initiative and many others. Just like to, before we get to the Q&A, just want to share a few other ways that you all can help and partner with Legal Aid Chicago. We would love your help as a volunteer, as Michelle mentioned. Also joining our ambassadors board would be terrific. We have our annual luncheon coming up on June 13th, and there's still time for firms and companies to sponsor the event. And of course, any donation that you make to us will help us continue our work for equal justice and ensure that clients who need help with eviction prevention and many other issues will receive the justice that they deserve. So we are now done with the planned content portion of today's presentation, and then we're going to turn over to the Q&A. Before we do that, though, quick reminder, we would appreciate it if you could fill out a brief survey about the presentation. So to do that, or if you'd like CLE credit, just click on the link in the chat and fill out the form. The panelists will remain to answer your questions, which you should type into the Q&A and at the bottom of your screen. And I know that we have questions that have come in, so ask for Dennericka to please take us through the Q&A.
Thank you. I have answered a couple of questions in the chat already about how to access Zoom Court, if there are broadband issues, and also the QR code. So the first question, does the right to counsel depend on the reason for the eviction? Would this apply to condo owners who are facing eviction due to failing to pay HOA fees?
I can say when condo owners come into eviction court, when they do get, they can request ERP. We have counseled some of them. Right to counsel, though, is for tenants. So that would not be a kind of case that we would be able to accept for right to counsel. We would be able to accept a case with a tenant renting from a condo owner, but not the condo owner themselves. Note, please spread the word if you know someone who's facing that situation because of HOA fees. IDA still has home ownership money available, and I can put a link in the chat, or you could email me directly if you wanted to know more about that.
I would just add that the CCLAD hotline will talk to both of those. I mean, whatever the reason for the eviction, we will talk to you. And, you know, if you're a homeowner, have a homeowner fees you haven't paid, we will talk to you there as well. So we can do a lot of help, whatever the reason is, through the CCLAD hotline.
But I do think that's a very important thing to distinguish, that there are fees available for homeowners or assessment fees, not just mortgage foreclosure. So thank you for sharing that, Michelle. The answer does bring up one of the other questions in the chat about what's the eligibility requirements for right to counsel. First of all, the right to counsel is pilot. So it must be a tenant in Chicago, the city of Chicago, and below 80% of the median income. So anyone that comes through ERP will be assessed for right to counsel to see whether or not they are eligible. But that's the best way to access right to counsel, 80% of the median income and a Chicago resident. And having a meritorious defense as well. It's not a right, it's a pilot. And so we want to make sure that we can have the most impact on cases that come in. Michelle, how long is the right to counsel grant funded in Chicago?
The right to counsel grant is for 3 years from July 22 to June 25.
I've referred many people to legal aid because they are facing eviction, but they've all mentioned that no one answers and they leave voicemails. To answer this question, I would say legal aid is a very broad umbrella. There are many legal aid organizations that have different capacity and different needs. I do want to say that if you have someone that is in eviction court, they have a case filed against them, even if they have not been, if they have an eviction case that's filed against them, send them to ERP. That is the way to access the legal aid agencies throughout Cook County, whether they're in the city or the suburbs. When you go into ERP, you have an opportunity to get matched with a legal aid organization. So go to court. Can't say that enough. Go to court to get access to legal aid. If it's someone who has another issue that is not related to eviction court, there's no cases filed, I would say for Legal Aid Chicago specifically, we have online intake where you can try to access our services or call early in the morning. Of course, being a legal aid provider, we all have limited resources and we cannot meet the need as much as we want to. So sometimes our phone lines fill up. So call in the morning. Reach out to CARPLS as well and Law Center for Better Housing if you need additional help, but it depends on the different programs. Pat, Michelle, did you have anything to add?
I'll jump in there. Yeah, I mean, there are a lot of legal aid programs and where they've called, we don't know. But what I always say is if someone's going to begin a journey seeking legal aid in anything, including eviction, that to call CARPLS, one of our hotlines, is the way to go. I saw in the chat someone asked what CCLAD stood for, and that's the Cook County Legal Aid for Housing and Debt hotline. And if it's in this housing area, I say call that hotline. That's the 855-956-5763. And we can get a client anywhere they need to go from there. We have an incredible volume of calls that are coming to that hotline. But when they call, they will not wait more than 20 minutes on the phone, hanging on hold, waiting to talk. We have an automatic callback system. So everyone who calls the CCLAD hotline will talk to an attorney. It's just they may get called back a little later through this automatic calling back system. So that's explained while they wait. So if someone really needs to talk to a lawyer, I would send them there. I would also say the earlier in the day you call, the more likely you are to connect to someone quite quickly. So yeah, send them to the CCLAD hotline.
I would be remiss if I didn't point out one of the services that LCBH has is to chat online with legal assistant. So like Dennericka said, if you're in eviction court, what you want to do is go to court. But say you have a question about housing, about conditions issues, whether an ordinance covers something or not, whether you're covered by an ordinance. If you, again, I'll utilize the chat function here, but if you go to either our website or to rentervention.com, you're going to get a cute little robot and you can ask it questions. It will give you some information. if it is able to answer your question, that way it can connect you with a virtual clinic where, again, a lawyer, a legal assistant, or one of our volunteer lawyers can help provide more information.
How much longer do you expect emergency rental assistance funds to be available to eviction litigants? We don't know. we just don't know. That's something that's out of our control, and I don't know if there's anything else to add. I think that we might be okay until the end of the year. I would speculate that, but I don't know.
I think the DOH would say through 2024. You know, again, it's a lot of prediction, but I know that there is great hope and planning for there to be rental assistance. I mean, there are other kinds of rental assistance as well. I'm assuming the question is the COVID era rental assistance. DOH would say through 2024.
All right, we only have a couple of minutes left, so let's try to fill maybe a couple more questions if we can really quickly. Who will the pool of attorneys consist of that represent right to counsel if it is expanded in some way? This is one of those things that I think that we don't necessarily know. Other jurisdictions have tried different things. In Washington, D.C., a pro bono program, New York, legal aid attorneys. Some folks have a combination of legal aid and private attorneys, some appointments. Things are being tried all over the country in different ways to see just what works and what doesn't. Right now, we're the two partners, Law Center for Better Housing and Legal Aid Chicago, but long-term, I'm not sure what it's going to look like. I think part of it will depend on how the program is funded, how the program is actually written. I would say that it's just a big question mark at this point.
I think it's going to take a lot of lawyers to do this type of effort well. And, you know, the legal aid community, there's only 450 of us in the whole state of Illinois. So we're going to need some kind of help if this, you know, really takes off. But it's a really good question.
I want to be respectful of everyone's time. We are now at the hour. It's 1 o'clock. Thank you so much for your thoughtful questions that really got us across the board. Thank you, Michelle. Thank you, Pat. You are just amazing housing advocates and do so much, and we just really appreciate you. And thank everyone else for taking your time and spending it with us over the lunch hour. And with that, I will pass it off to Kate.
An excellent conclusion, Dennericka, and that's going to wrap us up on our 2023 Legal Aid Matters webinar series. Thank you so much for joining today, and we can't wait to see you all at our luncheon on June 13th. Have a great afternoon.
Thank you.